Ahmed Khan and Shah Bano Begum. This is a landmark case. AIR 1985 Supreme Court 945. It is also considered as 1985 Criminal Law Journal 875 or even 1985 2 Supreme Court cases 556. You need to write any one of them, it will be correct. The decision was taken by 5-member bench of Supreme Court. They are Y.V. Chandrachud, Chief Judicial, D.A. Desai, E.S. Venkatarama, O. Chinnappa Reddy, and Rangnath Mishra. The Muhammad Ahmed Khan versus Shah Bano Begum and others, or the Shah Bano maintenance case, is seen as one of the legal milestones in the battle for protection of rights of Muslim women. While the Supreme Court upheld the right to alimony in the case, the judgment set off political battle as well as a controversy about the extent to which courts can interfere in Muslim personal law. Most of us forget the hard work done by the lawyer Daniel Latifi, so please do quote him as well, because it was he whose effort definitely brought the big change. Let's take up the fact of the case. In 1932, a lady named Shah Bano, a Muslim woman, was married to Muhammad Ahmed Khan, an affluent and well-known advocate in Indore, Madhya Pradesh, and had 5 children from the marriage. After 14 years, Khan took a young woman as his second wife, and after 15 years of living with both wives, in 1975, he threw Shah Bano Begum, who was then aged 62 years, and her 5 children out. Then in 1978, his wife Shah Bano filed an application for maintenance under section 125 of Criminal Procedure Code 1973. What was the issue then? The issue was the interpretation of section 125 of Criminal Procedure Code 1973, which provides for a summary remedy to a destitute wife, even if divorced, to seek maintenance from the husband by approaching a magistrate, then a civil court. Now the question was whether section 125 of Criminal Procedure Code 1973 applies to a Muslim woman, and whether section 127 of Criminal Procedure Code 1973 applies to Muslim women. Well, the Madhya Pradesh High Court said yes, and initially in 1979 the court ordered 25 rupees per month to be paid as maintenance. Later in 1980 the court ordered rupees 179 per month to be paid as maintenance. Now what happened is, Ahmed Khan, to avoid paying maintenance to his wife, brought religion into it so that he gets larger support in his favor. The court further observed that various authorities as well as the Quran imposes an obligation on a Muslim husband to maintain his divorced wives, who are being divorced without rhyme or reason, should not be thrown on the streets without roof over their heads and without any means, and are unable of sustaining themselves and their children. For these reasons, the court dismissed the appeal and confirmed the judgment of the High Court. Now, this what happened is, the intervener joined the case. All India Muslim Personal Law Board and Jamaat Ulema-e-Hind. Under Mohammedan law, Mahar, dower, is a sum payable by the husband to the wife on divorce. The amount of Mahar is split into 2 parts. One is prompt, which is payable on demand, and the other is called deferred, which is payable on dissolution of marriage by way of death or divorce. Now let's check the judgment of the court. Supreme Court held that Clause D of Section 125 of Criminal Procedure Code 1973 is applicable to all, irrespective of their religion. Doher, the Mahar, does not dissolve the Muslim husband from payment of maintenance under section 127 of Criminal Procedure Code 1973. Supreme Court also reminded that Article 44 of Indian Constitution regarding uniform civil code must be brought forward to remove conflicting ideas of the society. So this was a move towards uniform civil code as well. Now let's check what was the effect of the judgment. There was a lot of hue and cry by the Muslim fundamentalists. So Parliament passed a new legislation to counter the judgment. This is something unfortunate because the judgment was not against any kind of religion, rather, it was in favor of Muslim women. Anyway, let me not go into the depth of it because thereafter, new law was imposed. This is the effect of the case Shah Bano Begum, that a new law was implemented. The law was named as the Muslim Women's Protection of Rights on Divorce Act 1986. Now let's check the side effects of the case. Officially, or if you have to write in the examination, do not write side effects but do write the consequences of the Shah Bano Begum case. The consequences was that Muslim Women's Protection of Rights on Divorce Act 1986 was passed. Definitely it was passed. Then what it made the effect? Diluting the judgment, the act allowed maintenance to a divorced woman only during the period of iddat or till 90 days after the divorce according to the provisions of Islamic law. The liability of the husband to pay maintenance was thus restricted to the period of iddat only. Well, all the hard work of Shah Bano Begum, a lady who belonged to a very reputed family, who was fighting not only for herself but all the Muslim women, her hard work gone. Muhammad Umar Khan versus Gulshan Begum, 1992 Criminal Law Journal 899. The issue raised was that Muslim wife is maintainable under section 125 of Criminal Procedure Code 1973. Authority of Muhammad Ahmed Khan versus Shah Bano Begum and other was quoted. But the claim of Muslim wife was held not maintainable over here. Why? Because there was no declaration by the husband under Section 5 of the Muslim Women's Protection of Rights on Divorce Act 1986 consenting to be governed by Section 125 to 128 of the Criminal Procedure Code 1973. भाई हुआ क्या था शाह बानो बेगम केस में? डेफिनेटली सुप्रीम कोर्ट ने डिसीजन लिया था कि क्रिमिनल प्रोसीजर कोड जो है किसी रिलीजन को लेकर नहीं बना है. सो मुस्लिम वुमेन आर एलिजिबल टू बी मेंटेन्ड. उनको मेंटेन किया जाएगा थ्रू आउट द लाइफ आफ्टर बीइंग डिवोर्स्ड बाय अ मुस्लिम हस्बैंड. लेकिन न्यू लॉ बन गया था मुस्लिम वुमेन प्रोटेक्शन ऑफ राइट्स ऑन डिवोर्स एक्ट, जिसमें सिर्फ डिवोर्स के बाद 90 दिन के लिए ही मेंटेन करेगा, दोबारा वापस लागू हो गया था. सो मोहम्मद उमर खान वर्सेस गुलशन बेगम के केस में ये डिसाइड हो गया था कि शाह बानो बेगम केस को जो है वो नलीफाई कर दिया गया है बिकॉज न्यू लॉ is implemented, and that is Muslim Women's Protection of Rights on Divorce Act 1986. This is another landmark case on maintenance when divorce is taken by mutual consent under Section 13B of Hindu Marriage Act. Rohtash Singh versus Ramendri and others. 2003 Supreme Court cases 180. Honorable Supreme Court considered that where the husband had obtained a degree of divorce under Section 13 of Hindu Marriage Act 1955 on the ground that wife has deserted him, when the wife claimed maintenance under Section 125 of the Code, the husband took the plea that as per subsection 4 of Section 125 of the Code, she is not entitled for maintenance. But the Honorable Court held that the claim for maintenance under the first part of Section 125 of Criminal Procedure Code is based on subsistence of marriage, while claim for maintenance of a divorced wife is based on the foundation provided by explanation B to subsection 1 of Section 125 of Criminal Procedure Code 1973. So, if the divorced wife is unable to maintain herself and if she has not remarried, she will be entitled to maintenance allowance.